Okay. Well, it's now 10:30, and you're tuned to Brainstorming the Human Connection, brought to you by the South Dakota Humanities Council. And I will remind you that this is an interactive program. It's a program that's designed for conversation and just kind of getting used to having decent civil conversations and wrestling with ideas as opposed to just being passive sponges. That can be good sometimes, but it's useful to wrestle with ideas. If you have questions, you have comments, you have experiences that you can share with us to help illuminate the subject, to get others involved in a conversation, that's usually better than one talking head or two talking heads just throwing stuff at you. Yeah. The idea of learning together is a good thing. None of us will ever be as smart as all of us together, so the more of us that can get involved in the conversation, the better. Now, we have probably heard, or some of you have probably heard, conversations around things like land acknowledgement. Now we have scripts actually that people have because it's easy when your main topic is who knows what, to when you want to acknowledge the land you stand on is land that was basically taken from other people. It's not easy to sort of have the words, so we have scripts that try to encompass all of that. So you probably heard that at some point. Oh, there's a likelihood that you have heard that somewhere. We know that there have been lands that have been taken, and there are lands that are under dispute that were taken from Native Americans. And we have heard of talk about repatriation, reparations. Okay, what does it take to repair or to make good on, or to come to some kind of settlement? So we're going to talk about the background of that today, and we're going to have a chance to maybe understand a little better what's at stake, not only legally, and that's an important thing, but not only legally, but also emotionally. If we're going to finally live together and come to some kind of connection with each other, that we finally have an understanding, okay, I feel you, and let's find a way that we all share everything we have. In other words, we're not at each other's throat. We're not nervous whenever we meet each other. Some kind of way to think about it. I'm hoping this will be a contribution. This conversation will be a contribution to giving all of us a way to begin to think about these issues a little bit deeper. And my guest today is Frank Pommersheim, and he is a professor of law at USD and has been dealing with these issues for quite a while. Welcome, Frank. How are you today?
Good. Thank you, Lawrence. Glad to be here.
Good. Let's first start off with talking a little bit more about Frank. Can you tell us, like, where you're from, a little bit about where you grew up, and you're now a professor emeritus, as I understand now.
Yes.
Is that correct? Yeah, okay. And so I'd like to like take a short elevator speech journey over Frank Pommersheim's life, so that our guest here can understand from where you speak.
Good. I'm happy to do that, Lawrence. I was actually born in New York City and basically grew up there and had my education in the state of New York. I went to law school in New York City. I had no contact or understanding about Native or indigenous people in that educational trajectory and as I was growing up. And as I was graduating from law school, I saw that they were interviewing people to, if they were interested in joining a VISTA program. I don't know if you remember VISTA, Volunteers in Service to America, the domestic analog to the Peace Corps, to go to Alaska and work with Native people there. And although I had no background that prepared me for that, that was something that was interesting to me. I interviewed and was selected. And so I went to Alaska. I worked 2 years in Alaska as a VISTA volunteer / attorney, working with Yupik people in the Bristol Bay area and along the Nushagak River and in the Bethel area. And it was a tremendous kind of learning experience for me about Native people, Native issues, the culture, all those kind of things. And when I finished doing that, and I wound up back in New York, fortuity kind of intervened in a way that a friend of a friend let me know that a college was being started by Native people in South Dakota on the Rosebud Sioux Indian Reservation. And I had never been to South Dakota either. I obviously never been on the Rosebud Sioux Indian Reservation, but that sounded like really interesting to me. I came out, was interviewed, was offered the position. And at that time, my wife Ann and I went back to New York. I had never owned a car, so I had to buy a car first thing so we could drive out to South Dakota and begin to live and work on the Rosebud Sioux Indian Reservation. And I was on the staff of the nascent Sinte Gleshka College. And that's how I came to the state. My wife and I thought it'd be interesting to be in South Dakota on the Rosebud for a year or so, and we wound up living there 10 years. It was a transforming experience for us as individuals and professionals and as a family. And then I had a fellowship at Kennedy School, trying to decide what would be the next thing to do. And again, chance. I saw that the law school was looking for a person to join the faculty to continue to teach Indian law. I interviewed for that position and was offered the position to be a faculty member at the University of South Dakota School of Law to teach a full range of courses with a particular focus on Indian law. I guess I was still young enough that the horizon was still pretty short. And yes, Lawrence, 35 years later, I retired from the faculty and am now an emeritus faculty member. I've written quite a bit in the area of Indian law. I did a lot of work as a tribal appellate justice, and I continue to serve on Rosebud Sioux Supreme Court, Chief Justice for the Flanders Santee Sioux tribe, and also on the court and for the Winnebago tribe in Nebraska. So that's kind of the nutshell version.
Yeah, well, that's a lot. That's a lot. I don't know that we'll even remember all of it, but it gives us an overall view that Frank has, let's say, he's got skin in the game, so to speak. There's a lot of words that get tossed around relative to the status of native lands and the history and things like that. Three phrases that come to mind are land acknowledgement, land return, and reparations. Can you tell us what are the concepts under those three headlines?
Yes, for me, it goes like this. Land acknowledgement, in many ways, is the beginning of a process. It's not really an endpoint. And land acknowledgement, just as that phrase indicates, is when individuals, organizations, public institutions, South Dakota Humanities Council has its land acknowledgement. And to me, a key thing about land acknowledgement is the word respect. It's the beginning of the dominant group saying to Native people, we respect your history, and we want to acknowledge that history, however problematic that history is, and perhaps establish a foundation of respect so that we can go forward and do more and better things, to try to put a better history together. So to me, it's a predicate for action. And, you know, you hear them in all different kind of formats at different places. And that's the beginning. Native people, my native friends, are always very clear to remind me, Frank, it's a beginning. You know, we've heard words a long, long time, but for us, this is a necessary beginning, with the operative key word being respect. But then we have to go on to some kind of action. And those actions can result in land return. I think particularly for tribes here in South Dakota, land return is the key next step. And then maybe ultimately a kind of reparations. But I think land return, with the taking the theft of the sacred Black Hills by the United States government in 1877, that's a lingering wound that for Native people, for Lakota people, that's, I think, the primary focus they would have in the context of land return. There are also other intermediate things along the way that individuals and institutions can do. It's not like nothing or land return. I believe there's a continuum of things that can be done that are respectful, helpful, and in good faith.
Mm-hmm. And how about reparations?
Well, reparations to me is in kind of the far end, because I think from the general thinking about reparations, particularly in the context of African Americans, largely seems to have to do with admissions and like money and, you know, transfer overdue by the federal government or state governments or any institutions to African American communities to try to deal with the past, provide opportunities to go forward in a mutually acceptable way that is beneficial. I don't know of any reparations by the federal government in the Native context. I mean, there have been awards in court where tribes have been awarded money, but they're really not in the nature of reparations per se. A couple of weeks ago, I was looking at the Minnesota Tribune, Minneapolis Tribune paper, and it indicated a number of churches on their own in the Twin Cities area have engaged in reparations of payments of money to tribes in their area. So for me, I think in the Native context, we're more at the stage of land return and other kind of things, and not quite in the context of reparations. You know, reparations might make sense, although Congress has yet to pass the bill before to establish a reparations commission in the context of African Americans, and to do, you know, a full-blown study about what that might involve. And, you know, perhaps at some point there ought to be an analogous commission established by Congress to look into the larger issue of land return and reparations in the indigenous context.
Well, you know, as far as the land acknowledgement, I know that the Humanities Council has a statement. I'm wondering, Carolyn or Jennifer's on this call as well, if one of you could pull that up and maybe put it in the chat, and maybe at some point, once you have it, we can read it for those on the call so they get an idea of what such land acknowledgement statements sound like, in the event that some people have not heard one before. I think it would be useful. When we look at land return, you spoke of like a continuum, okay? Talk to us a little bit about that continuum. You know, what does that look like? We talked about the Black Hills. Talk about, if you would, what's under the hood of that and that continuum.
Yeah, for example, institutions, educational institutions like the University of South Dakota, including private universities, they could say that one of their responses is that they're not in a position to actually engage in land return because they have no land to return. but they could try to enhance opportunities for Native students to come to those institutions, to enhance the financial aid that might be available to Native students, to help establish institutes at universities that are particularly dedicated to the education and support of Native people. And let me give you like a good example. There was a federal statute passed in 1862 called the Morrill Act, and it authorized the federal government to take land from Native groups to provide for the establishment of land grant institutions in various states, including South Dakota. In fact, our land grant institution is South Dakota State University. And so the land that SDSU was on was arguably taken legally through the Morrill Act. And SDSU is aware of this. In fact, the president of SDSU is a member of the Rosebud Sioux tribe. He's acknowledged this problem, and he has led his institution to try to recruit more Native students, provide increased scholarship opportunities. He's established a particular institute there called the Wakini Institute. So to me, that's a good example of acknowledging the wrong, not really in a position to engage in actual land return, but since it's an educational institution, enhancing material and cultural opportunities for Native students. And I think the president of SDSU has done an excellent job about doing this, acknowledging a wrong and saying there are things we can do as a public institution in the state, and we're going to do them.
But there, okay, so that's kind of one end and an example of land return. Has there ever been any actual returns? I know that there's some, at least I understand that there's some clauses in the, let's say, treaties with Native Americans that when the government lands that are taken by the government, when, and let's say made a park or something, if the U.S. government no longer is interested in that, it goes back to them or something like that. Or are there any cases where Native Americans
Well,
have?
I would say there are a few, and it requires an act of Congress to effectuate land return. And there are some examples where the Blue Lake area was returned to the Taos Pueblo in New Mexico. Arguably, the Massive Land Settlement Act dealing with Alaska Natives and indigenous people is an example. But the examples are, I would say, rare, because courts, when they generally are empowered to hear cases involving the taking of land, they usually consider the only remedy available in a judicial proceeding is money. And so there are a significant number of cases in which various courts, including the United States Supreme Court, have found that land has been taken improperly from Native people, and the remedy is money. And money's not nothing, but oftentimes from the Native perspective, when land return is possible, that's, I think, where Native people want to see action. Whether it's still possible is a tricky word, for land to actually be returned to Native people, it ought to be done. And in South Dakota, we have a very powerful example. The federal government took the sacred Black Hills from the Lakota Nation in 1877, cutting kind of to the chase. They tried to comply with the Fort Laramie Treaty of 1868 that says expressly in Article 12 that if there to be any future land cessions by Lakota people have to be approved by 3/4 of the adult male population. And once gold was discovered in the Black Hills, there was that rush, both physically and emotionally, to get that land where gold was, despite the fact that it was part of the Great Sioux Nation. And the United States tried. They sent two different commissions out, the Allison Commission and the Penny Commission, to try to get approval of 3/4 of the adult male population, and there was some offer on the table. And in both cases, they couldn't get anything approaching approval of 3/4 of the adult male population. And so they reported that back to Congress. We don't have it. So one might think, well, if you're sort of going to adhere to the treaty, it's like the treaty stays in place. The land base making up the Great Sioux Nation stays in place. That's the way it ought to be. But Congress just decided, well, I'll pass a statute. And they passed a statute, very short statute, in which it took 7.7 million acres out of the Great Sioux Nation, including the sacred Black Hills area, and that was no longer part of the Great Sioux Nation. And at the time, that taking in 1877, you might wonder, well, what did the tribes want to do? Well, of course, they wanted to sue, but there was a rule in place at the time that the United States would assert its sovereign immunity in any case brought by a native tribe seeking land return. And so from the get-go in 1877, there was no option to go to court until there was a special statute passed just for this case in 1920. And so the case actually began in 1923, and it's a long, interesting case, but I'll just cut to the Supreme Court's decision in 1980, in which it decided that this 7.7 million acres was taken illegally because the government failed to pay for it. It said it could take it under the Fifth Amendment eminent domain, but they forgot one thing. They didn't pay for it. And so the court ordered that they pay for it. And from the Lakota perspective, I think it would be fair to say that wasn't enough. They wanted the land returned. And to be sort of clear about this, by the time the court case got to the Supreme Court in 1980, out of that 7.7 million acres, roughly 1.3 million acres was still held by the federal government. The rest of that land had found its way into largely private ownership. And I think Lakota people, and this is to me like a critical thing, because sometimes when people say, Native people want the Black Hills back, it's like, well, high up there as an abstraction, it's like pretty good until they might be talking about land your family owns in the Black Hills. Well, that kind of changes the complexion of it. But to me, Lakota people have always been clear. They don't want to take any land away from private landowners in the Black Hills. They are interested in the land return of the land still held by the federal government. And I think that's important to get out there, because my own experience of speaking about this for many, many years is like you can feel a sigh of relief when I'm speaking to non-native audiences and make it clear, like, they're not coming for your land. Lakota people aren't like that. They're just saying the federal government still has a big chunk of our holy land, and that's what we want back.
This brings about a very interesting point, though, especially, being a judge. There's this thing called treaties, okay? And the point of a treaty is like the parties agree, and unless both of the parties agree to change it, the treaty stays in place. So what does that do to our standing when we can look over all of those treaties? It's not just this one, but all of those treaties, and see how many times that the U.S. government has abrogated or abandoned treaties that made. What does that do to our standing to make treaties with other people? How does that make us look?
Well, it makes us look very bad, because if you think about the basic definition of treaties, it's an agreement between sovereigns. And the idea is each sovereign has made promises and gotten promises in return. The notion of a treaty is a bargain for exchange. And so I think that's how Native people understood it. Many Lakota treaties, at the conclusion, of be a smoking of the holy pipe, indicating that this was more than a sin legal agreement. You know, it was an agreement between people. But that's not the law of this country. The law of this country is, and it is still the law, that Congress may unilaterally abrogate any Indian treaty or any treaty, any other treaty. And this rule was enshrined in an ugly case decided by the Supreme Court in 1903, Lone Wolf versus Hitchcock. So in the Sioux Nation case, it wasn't like that the United States couldn't abrogate the treaty. The understanding was that they could, but when they did and took the land, they had to pay for it, and they didn't. And that's the ongoing kind of tension that continues to exist. I mean, there's a portion in the Constitution that talks about treaties being being the supreme law of the land, but it's not the rule that has developed at the Supreme Court in 1903, and it remains the law of the land, so to speak.
I think, at least for me as an American, that is a thing that really bothers me deeply, is that if you're going to make an agreement with someone, and we say as a moral issue, if I promise you something and I promise, you know, we come to an agreement with something, my word is my bond. We often say that, you know, it's like if you can't depend on a man's word, then you can't depend on him, you know. And if we hold that as some sense of a sacred, understanding between human beings, without which, how do we come to negotiate with each other when it can be assumed that if I change my mind, then the agreement's off? You know, it's like, well, how do I negotiate with you? Not only person to person, not only person to government, but government to government. How do I negotiate with someone or an institution that is known for just, oh, that thing we said yesterday, now that I got what I want, that's not a thing anymore.
Well,
that seems to be problematic.
Well, it is problematic. And part of this whole trajectory we're talking about, in some small way, might be an attempt to change that historical trajectory, where the notion is we can make promises, but we don't have to keep them. Well, maybe if you're an optimist or a realist, and hopefully an optimistic realist, I just made that phrase up, is the idea that we can change. You know, that we can admit that the way we have acted in the past has not been honorable. We didn't honor our own promises. We can fess up to that and say, let's go forward, and, you know, we're going to be different. We're going to honor our promises. And, you know, it's in a conversation, and Lakota people, indigenous people on the other side of that conversation have to be convinced that it's going to be a new deal going forward. And in the context of what we're talking about here in South Dakota with the Black Hills issue, that issue isn't finished. You know, there's a way to go back to that and still make it right going forward. I always would say to people, the Black Hills issue is unique in this way because there's still a second opportunity to make it right. You know, to return that land. It's very complex legally. I'd be the first person to admit to that, but it can be done. And so, you know, land acknowledgement to me is like the predicate of saying and admitting and showing respect about some of these things that happened in the past, and then asking the question, what can we do? Are we just stuck with that ugliness from the past? And I would argue passionately in the context of the Black Hills, it's like, no, there's still a way to go forward and admit that wrong and to a certain degree actually correct that wrong and to develop a better history to go forward with. I mean, I believe we're capable of that. We haven't seen too much evidence of it yet, but that's what you have to be optimistic about. And land acknowledgement, I think, is a small step in the right direction.
Great. I want to open it up now to our esteemed panel. All of those who are on this call, you're our esteemed panel. And anybody have any questions or comments, additions, experiences? How are you feeling about this? Anybody can raise your hand or just turn your mic on. Steve, you look like you're ready to say something.
Well, as Professor Pommersheim describes, it is an immensely complex issue that obviously originates in two things. And when I say originate, I'm going back to the 19th century. First of all, obviously, our private financial interest in simply taking, okay, and of course that's largely responsible. But the second issue is an incredibly total lack of understanding. If you haven't read, you should read Dan O'Brien's two novels, The Contract Surgeon and The Indian Agent. And he does an immensely wonderful job in demonstrating and characterizing and describing that complete lack of understanding. And they're both about Valentine McGillicuddy, who was an actual person, historically. In fact, he was mayor of Rapid City after he left the Pine Ridge, and also, interestingly, wrote a very passionate letter to the general in charge of the Army right before the Wounded Knee Massacre, telling him to back off. Don't worry, just be calm. And of course, it was ignored, and we have this lingering tragedy. But the idea of returning federal land, to the tribes, obviously is feasible. I mean, you're not taking away private land by definition, and so the issue would be, okay, if that is possible, what's that look like, and what's going to happen? And of course, there's not been a huge amount of definitive discussion about it because we're not there yet. But it is obviously immensely feasible, and who knows? And of course, okay, you're going to have to pay for it, and that's what happened in 1980. But money's not the issue primarily, and while we can say, all right, we've done our job, so to speak, it ain't done.
Yes.
I by coincidence, years and years ago, sat next to the president of the bank on the Blackfoot Reservation in Montana, and she was the named plaintiff in what led to this. And she had a very, very unique, interesting, and accurate perspective about all this. But in any event, in the history of conquests that goes back over centuries and centuries and centuries, once the land is quote unquote conquered, over time, the residents of the conquered land sort of become the conquerors. In other words, they migrate in understanding and even language and all these other things, and of course that's different with reservations. I mean, and so it's just with us forever.
Yes. Well, one of the things that your explanation and comments bring up is a fundamental problem with the concept of ownership.
Yes.
And that is so complex, especially when you think, well, the first people stole this stuff, not only stole it, but killed the people. It's like somebody comes in your house, rapes your wife, and kills you. And now he's complaining that somebody's stealing the thing that he stole. It's like somehow that just seems absurd. So it becomes problematic when we have just having the idea of ownership, especially when it's like land, which you didn't make. Nobody made it, It's like owning sunshine or owning, water. We say we have owning water rights, right? And so it's like, yeah, but you didn't make the water, and the water is continuous. So it's not like you had this one supply that you sell and then, it's like it's always being replenished and you're not the one that's replenishing it. How is it that, that a person, a group owns something and then are positioned to punish those who take it from them? That's a concept that, whether it's in law or not, is very difficult for me to wrap my head around.
Right. Well, it's this great scene in the Indian Agent where McGillicuddy comes face to face with Red Cloud for the first time, and by then the reservation of Pine Ridge had been laid out. It was bigger then than now, but he was explaining to Red Cloud, hey, there are only 8,000 of you here, okay, and you got all this land. And of course, he's thinking to himself, good grief, if only Ireland could do that, because that's where he came from. And don't worry. I mean, we'll teach you how to farm, and we'll give you tools and plows and all this stuff, so you can use the land profitably. And of course, Red Claw had a translator and said, well, you white people can labor all you want, but the spirit gave us this land to be hunters and fishermen, not laborers. And of course, that scene really highlighted the total lack of understanding.
Yes.
It's just, there was just no way that he could get it. And it didn't make him out to be evil. It simply cast very, very effectively the dramatic lack of understanding. And your point about land ownership is right on that way.
Yeah, and I think we see that in other cases, especially cases for reparations or whether it's war reparations and all those things. One, we have this sense of ownership, and two, we have this subtext that whatever it is, if I give you some money, which is basically just paper that we just agree that we can do stuff with, doesn't have any intrinsic value. I give you this paper, and then that's supposed to make everything go away. There doesn't seem to be anything intrinsic in the transaction, or inherent. There's no inherent value in money. It's just that and you can tell that by inflation, it's like the money is still the same. So if the house costs more, it means that the money is worth less. So if I give you money for your land, and then I raise the cost of all your goods, I basically take the land away from you again.
Sure.
So anyway, it's just something that occurred to me while I engaged in this kind of conversation. I'd like to open it up. Anybody else who has any comments that they want to add to the conversation? Questions?
I have a question.
Go ahead, Lanico.
There are lands that are held in the hills by churches and oftentimes overlooked by others, that this is the sacred Black Hills. So these churches have land mass area. And wouldn't the return of these lands be the beginning for opening up the discussion about returns? You're right about money. It means very little to people who have had a long tradition, a long history of using the resources that were available, not transforming the resources that are underneath the ground to make kinds of the various things that are modern, contemporary, American, and otherwise material things. But it occurred to me that these lands in the hills that are of churches are actually replacing by their presence the use of that area for those who use it among the indigenous people for gathering for various reasons. I know as a child, that was one of the reasons why we went to the Black Hills from Standing Rock and Cheyenne River, was to forage. There were seasons of foraging going on, and those areas have been closed off to people like us. I just thought I'd bring that up.
Well, one thing that your comment brings to mind for me, Lanico, is that if you have a church that, let's say, superimposes its idea of spirituality and religion onto the religious or the spiritual area of another, somehow that seems kind of like not right. I'm not sure I know how to say it, but it just seems like a disconnect to just say, well, this thing that you thought was spiritual, that's not really a spiritual thing. We're going to put our idea of spirituality on it, and we're going to enforce it on you. By various means, you enforce that in spirit. You use even the force of law to enforce your spirituality on people. And I'm not sure how spiritual that is. It's like this. So anyway, that sounds like something that's just weird.
Well, if I can chime in, one of the basic legal doctrines that justified the taking of native land was this thing called the doctrine of discovery. And when European nations were coming over here, they were all Christian nations from Western Europe, and they had questions that they directed largely to the Pope about how should we treat these people. Are they human beings like us and we have to respect them? Or are they lesser than we Christians are and we can deal with them however? And the Pope issued several, they're called bulls, papal bulls, in the 14th and 15th century that expressly said that native people, unless they were Christian, were not full human beings, and it wouldn't be improper to take their land. So that religious doctrine skipped the part about respecting beliefs. It was like just giving the okay from a Christian Catholic perspective in particular, that it was okay to treat Native people and their land as not theirs, really. And you can read in the famous case of Johnson versus McIntosh, decided by the Supreme Court in 1823, which established the law of the land being the doctrine of discovery. It said that express thing, that it was okay for us, we got title to the land by discovering it, always in quotation marks. And those people who were here, we, by discovery, we became ours. We had property ownership of it, and Native people continued to have a few sticks in the bundle of property rights, the right of use and occupancy. So the very root comes from the Catholic Church. And only recently, I don't know if anybody knows it, I mean, the Pope has finally said, no, we were wrong. But the follow-up is to, we were wrong, and this is where the conversation kind of falters. Like, what are you going to do about it? Yeah. You know, the first step is admission, just as like in our personal life. The first step is admission of wrongdoing. As a pro, I've wronged you. But the next step is, what can I do to get us back in a relationship? And we're still struggling in a lot of ways at the first step about admitting the wrong. And to go back for a minute to some of the things that Steve was saying, I know from speaking about this issue for 30 plus years, part of the problem is, in my view, is that the citizens of the state of South Dakota, they don't know any of this. It's not their fault. I've spoken many, many times over the years, and many non-Native people tell me after, Frank, I never heard a word about this. I was educated in South Dakota public schools, even at the university level. I never heard about the Black Hills. I never heard about the Fort Laramie Treaty of 1868. So when you don't have like the basic knowledge, you're easily, my view would be, you're easily victimized and taken advantage of by your own government. And so when talking about land return in the Black Hills, to me, there needs to be, and in a small way, there is some bubblings around that, to continue sort of a process of education, to not only say something about the past, but explain it in ways that are honest and convincing and respectful. And my experience is that good people, like most of the people in South Dakota, when they hear that new information, you know, their hearts open up a little bit to say, well, I might have to rethink what I've thought about this or what I haven't thought about this.
I think it, go ahead, Vicki.
I was thinking about that just before you spoke. I think that I've just come back to South Dakota, back and forth for 24 years. But what I hear is that people are becoming more sympathetic to giving back the land because they have a little bit more information, but not too many people. It seems like it goes back to that when you were talking about the history of conquest. I think that most people, especially the older people, feel like my parents settled this land and it's mine, sort of thing. You're not going to give it back. I think now, if the general population of South Dakota feels that way, are you going to rely upon the population wanting it to be a certain way, or is it just going to go back to the rule of law? I know that that's kind of the two that contradicts each other. So, you know, tell me, is it the rule of law that's going to make this possible, or did the people having that idea, my grandparents settled it, it's ours? Is that going to have any bearing on whether or not it goes through?
Well, I would say in the context of the Black Hills, it doesn't involve my understanding and working with and knowing Lakota people. I was living at Rosebud when the case was decided in 1980. You know, I think Lakota people never wanted to take land away from private landowners. And I think that's an important thing that has to be made clear, is that fortunately, I would say there's still 1.2 million acres of that 7.7 million acres that is owned by the federal government. And I think that's generally been the focus of what can be returned. And I think it's important that people, understand this so that they don't fear that something is going to be now taken away from them. I mean, I just think that's like a fruitless avenue, and that's why it has to be made clear continually that Lakota people, in my experience, the Sioux Nation Black Hills Act, the proposed statute to actually return this land, expressly states that it does not intend to take land from private landowners. And you have to continually, I think, get that out there so you can have a meaningful conversation to go forward. And it is unbelievably complicated. I would say myself that you couldn't really put together an effective return of the Black Hills, a new Sioux Nation Black Hills Act, without probably 5 years of in-depth study, because it is unbelievably complex legally. At some high area of abstraction, you can say the federal government should just return that land. Well, unfortunately, as Steve knows, lawyers, it's just not that easy. I wish it was, but it's not. And I think it requires good, committed lawyers working with Lakota people. I have Lakota lawyers figure, how do we do this? I mean, when the land's going to be returned, who's actually going to own it? And is it going to be trust land or fee land? Or who's going to govern it? A small thing to keep in mind that when this actually occurred, this involved an entity known as the Great Sioux Nation. But as a matter of law, that no longer exists. The Great Sioux Nation now is made up of 8 discrete tribes. And that's just another complicating factor, which is unique in this particular context. The Great Sioux Nation is not one entity, no longer exists as a matter of law. There are 8 separate, discrete Lakota Sioux tribes that now make up the Great Sioux Nation for purposes of the case. And maybe, I don't know, my students know when I say one last thing, they know I'm not telling the truth. I know it's just like a predicate to saying some more things. But one thing, just to be clear about the money, is that money has never gone to the Great Sioux Nation. They never got the money. They don't want the money. But if you just stop there, I think that's an erroneous statement. They want the money plus the land return. And that amount that was awarded in 1980 was 13.5 million acres based on the evaluation of the taking in 1877, but with the taking interest, 5% interest runs. So in 1980, that 13.5 million was worth roughly 110 million. You know how much it's worth today? It's just sitting in the United States Treasury. It's worth over $1 billion. Yes, $1 billion. And it's just sitting there. And I think the overwhelming commitment of Lakota people is they want to see something happen that involves, for lack of a better term, marriage of both of those, a return of the land and the money. And it's just unbelievably complex. But to say it's complex is only an admission of the truth, not an excuse not to do anything.
Right. But that brings us. Yeah, go ahead, Steve.
I'm chancellor of the Episcopal Diocese of South Dakota, and of course we have a large number of mission congregations in all over the state, and we're in the process of and have been for a long time of considering, our role and what happened, and in okay, now what? Some of the land we have for mission churches was acquired by deed from enrolled tribal members. Others we got from the Department of Interior that sort of thing, and how that works is different. But we don't actually own anything of any what you would call monetary value, and we work very hard at serving Native congregations who use these properties, and in fact it's a complex topic. Back in 2008 and 9, we attempted and got it done, gave back to the Oglala Lakota tribe 9 locations, mission locations, and we got sued. We got sued by the people who wanted them to stay separate from the tribe. I mean, Native people, and so there's not a unity of views about this, other than we in the 19th century we were not the most understanding of people about Native spirit and its relation to what we believe. So, but it's in our minds every day.
That it keeps coming back to this complexity of ownership, especially since we put such a great weight on that in our law, but we don't really seem to have an understanding or defining of it, and it makes the morality of it often complex, because we don't seem to have any let's say any better understanding than mine as to what do we mean by ownership. Owner, I'm not sure what your name is, but you call yourself owner, so I've been talking about ownership, so I guess you would have something to say about that.
Well, I'm owner because I can't figure out the technology to put my name in the computer. This is Greg Redlin from Vermilion, and I know some of the esteemed panelists. I just one comment. Very happy to hear. I've lived in South Dakota most of my life and have read and thought about these issues a lot. And this was the first time that I heard someone suggest, especially someone who knows the issue as well as Frank does, that return of the hills is not meant literally. It's meant as some sort of negotiation, including both the reparations that were appropriated as well as the federal lands. And I don't think that's very well known in South Dakota at all. And more power to Frank and others in communicating that possibility. But I actually have a question, and it's for Frank Pommersheim. Frank, can you help us understand the Knight versus the Rosebud Sioux Supreme Court case that was settled in 1975, I think? Can you help us understand what the issues were and what the consequences of the decision were?
Yes, I can. I'm very familiar with that decision. In the latter part of the 19th century and over into the early part of the 20th century, the federal government was more and more interested in being able to obtain land within Indian reservations for people to settle, because most of the land outside the reservations was already taken. And so oftentimes Congress would pass a statute about a particular reservation or part of a reservation that basically said that land that hadn't been allotted to individual Indian people within a particular county would be open for non-Indians to settle. And there was no doubt that Congress could do that legally. the question became like, when Congress was doing that, were they actually using their power to reduce the boundaries of the reservation, or were they saying non-Indians can come and homestead, but they'll be homesteading on the reservation? And in the Rosebud cases, they first did it in Gregory County in 1904. They opened Gregory County for non-Indian settlement. And then in 1907, they did it for Tripp County. And then in 1910, they did it for Millette County. And the lingering legal question was, did Congress actually mean to reduce the boundaries, the legal boundaries of the reservation, or just to keep the original boundaries intact, saying that non-Indians would be able to homestead? And in the 1980 decision, the 1970, I think it was 1976 decision, the Supreme Court said that in each one of those acts, Congress intended to, the word that's used, to diminish the boundaries of the reservation. And so today, legally, the legal boundaries of the reservation are, or is, Todd County. And where Native people live outside in those 3 counties I mentioned, there's still tribal communities there, but they're technically not part of the reservation. And that was known as the diminishment process. And, you know, my view, shared by some people, I think, is that, the decision by the Supreme Court, they just like look at the population in those counties. And when they saw that there was, by the time the case got to the Supreme Court, significant numbers of non-Indian people in those counties, it was easy for them to say that it was Congress's intent to reduce the size of the reservation. But when you read those statutes, they don't mention that at all. So that's it in a nutshell. So you have to kind of, Greg's is an important thing. If like, there's a Milks Camp community as an example in Gregory County. People lived there all their lives thinking that they were actually living on the Rosebud Reservation, only to find in 1976 that the Supreme Court said, like, no, you haven't actually been living on the reservation. You just think about how powerful a blow that is to individual people to find out the place that they had lived their entire life on legally wasn't what they thought it was.
Well, with that, unfortunately, we have run out of time. We will need to pick this subject up again because there's so much to cover. Thank you all for joining us, and we'll see you all next week.
Thanks,
Thanks everybody listening and chiming in, and thank you, Lawrence.
Hi, Steve. Hi, Frank. Thanks a lot. I'm going to contact you, Frank, about more information on that.
Okay, you have to buy me some coffee first.
All right, will do.